have to reach out to a professional who specializes in this area. It's not a do-it-yourself situation, but the consequences are huge because, you know, the taxes can be anywhere between 27 and 54% of your assets.
It can feel like it's for the really rich or someone over there, and it like, oh, I don't have an estate, I can't think of it that way. And
the best crafted estate plans and drafted wills tailor exclusively to your own circumstances.
Start as soon as you can. You can always start it off and you can make changes later. You'd rather have something than nothing at all.
From the Zoomerplex in historic Liberty Village, the Zoomer with Libby Znaimer.
Welcome to the Zoomer. I'm Libby Znaimer. For many, discussing death is uncomfortable. Who really wants to think about it? However, difficult as it may be, it can make all the difference to those we leave behind and the causes we care for most. We've gathered a panel of experts to discuss everything you should know about planning your estate. But before we dive in, let's tee up the topic.
They say a goal without a plan is just a wish. And when it comes to our estates, too many Canadians rely on a wish. Over 50% of Canadians don't have a signed will. And of those who do, 15% are out of date. 25% say it's because they're too young, while 23% blame a lack of assets. Another 8% say they don't want to think about death.
Oh, dear.
While 18% believe they can't afford the legal costs. But not having a will is more problematic than you think. This little oversight can cost thousands in legal bills and can leave your family in a bind. So don't leave it up to chance. Plan for your estate in advance.
Okay, so in your experience, why are people so hesitant?
Well, in my experience, people don't like to talk about death. They don't like to confront their own mortality. They don't like to think about what's going to happen after they pass away. So it's easiest to just do nothing. And a lot of people don't realize that by doing nothing, by sitting on their hands, they're actually creating a bigger problem later on. So much of it has to do with not wanting to confront that, but I think there's a lot of ignorance out there. In fact, you're making the situation a lot more difficult for your loved ones, your friends and family after you pass away, if you haven't done that planning in advance.
Bob?
I think a lot of people have the misguided notion that if you pass away without having dotted the I's or crossed the T's of a will, for example, that it'll all go to my spouse or it'll go to my spouse and children in a nice, organized way without realizing the rather arbitrary nature of how these things work. In some other circumstances, people make individual transaction decisions like assigning their RSPs to their children rather than to their spouse, creating a big tax problem when they pass away. So there are steps that people, you know, anecdotally hear from their next door neighbor or plumber that say this is what you ought to do. They go ahead and do it and don't affirm it with someone else because, again, back to the first comment, they don't want to think about the death part of the equation.
Candace?
Definitely agree with Matthew and Bob. The other thing I notice is people don't have a trusted advisor to help them through the process. It's a very daunting process. There's a lot to go through, a lot to think about, and if you don't have some people on your side, on your team helping you through it, it's a lot harder to go through it. So have some good trusted advisors around you, and then it'll be easier.
Mark?
I think that most people spend their lifetime in the area of investing and not in the area of planning. And there comes a time in your life where sort of the philosophy of what you need to look at really changes. You have to look at preserving now your assets and look at income and look at tax efficiency. And getting to the point what you said, Candace, I think that you really have to reach out to a professional who specializes in this area. It's not a do-it-yourself situation, but the consequences are huge because, you know, the taxes can be anywhere between 27 and 54% of your assets that go to the CRA if you don't do proper planning. So I think that should get people's attention to do some planning while the sun is shining.
Mm-hmm. I think I'll just build on many of the things that you guys have been saying. For sure, one of the pieces that comes to play is when things are going well, it's totally something to just ignore and not think about because it's not front of mind and it's fine. I think the concept of estate is also something that puts people off. This idea of planning for your estate, thinking about your estate, it can feel like it's for the really rich or someone over there, and it like, oh, I don't have an estate, I can't think of it that way, and so it just this feeling of, that's not me, I can't do that, and so that feels like a piece that's really important to get past.
The other thing is, don't worry if you want to make changes. You can always start it off and you can make changes later. It is a process, so sometimes your first round, it's not exactly how you want it, but at least get it started, at least have something down, talk to your lawyer, and you'd rather have something than nothing at all.
I think it really is looking at things very holistically. A lot of people are very myopic. We look at one thing, or accounting, or our will, or whatever. I think it's really having a big picture and gathering all the information you need. I kind of look at it as akin to going to the doctor. You can't get a prescription until you've done a proper diagnostics. If you do that, I think they call it malpractice. So I think it's important that people go through a deep dive to get everything on the table, and then basically working with a team of professionals, because you can't be everything to everyone. You have to have a team that helps you to organize things in a proper way.
Okay. When we come back, we'll talk about wills and how to make sure that yours is ironclad. Stay tuned.
You may want to have a third party involved, especially if you think that there's some family resentment brewing or something under the surface that you think may explode when you're not there to referee anymore.
Welcome back. More than 50% of Canadians do not have a signed will, and this can lead to a myriad of problems for dependents and loved ones who are left behind. What should everybody know before sitting down and preparing a will? Who wants to start?
Well, I'll start. I think the most important decision you need to make, and this we talked a little bit about this before, is who's going to be your executor, who's going to be your estate trustee. And it's anyone who's done it before will know it's a big job. It takes time. It could involve meeting with professionals, trips to the bank, signing court documents. There's a lot there. And you may want to pick someone who doesn't run in the other direction as soon as they see some numbers on a page. So that's something you want to make sure that you have clear in your head. And it's also a good idea to pick an alternate too, just in case your primary choice can't do the job or isn't around anymore. So I always say that's one of the most important and one of the first jobs that people should think about when they're looking at making a will and planning their estate.
In my particular case, as I've aged and my kids have grown, my oldest daughter happens to be the executor for my estate. And to comfort her in the process of having to worry about all the things she needed to deal with, I laid out the team of people she could refer to help her through the process, because she expressed tremendous discomfort over taking this responsibility. And the critical issue was for me to give her a roadmap of who to deal with and to get support technically from a tax, insurance, banking, and otherwise perspective, and as well to lay out, in addition to putting a will together, a statement of wishes in terms of how to execute things, so that she had a roadmap of what I was looking to accomplish rather than just the black and white of who gets what.
Well, that's an interesting point. I don't know how many kids you have, but is it usual to appoint one out of several kids as the executor? Does that cause resentment, or do people appoint? When my parents passed, it was all three of us.
Well, I've seen it both ways. I don't think there's a hard and fast rule. It can depend on the circumstances. And one of the things that I like to talk about is having a discussion with your potential estate trustees or your kids, if you're going to name them. It may be that one's not interested in the job, or it may be that you think that they probably can't work very well together.
And sometimes, even with the executors, it's sometimes better to not have family as the executor. I had a situation where an elderly gentleman had 3 children. 2 of them lived out of town and 1 was in town, and he died, and it took 7 years for that estate to be wrapped up. because the kids all hated each other. They wouldn't agree to spend any money to open up a safety deposit box. This one was
What?
punishing this one. This one was punishing this one because mom gave him the bigger piece of cake, you know, when they were 10 years old. And it's a time when all of those personality conflicts come out. So he had said to me, it would have been much better to have the accountant be the executor, have all the assets come in and just split it up a third, a third, a third, as opposed to having people worrying about making decisions and getting along and playing in the sandbox.
I mean, and sometimes depending on how much time it's going to take and how complicated it is, your family members can take a fee because they have to spend that time doing it. So.
That can happen, and sometimes that also leads to a little bit of resentment, especially if you have one of your kids who's taken on the job and they're taking on a fee because of the work they did. The others will invariably say, well, you didn't really do that much. That didn't take that long. That wasn't that hard. It's just another potential point of conflict. So to Mark's point, sometimes the circumstances dictate that you may want to have a third party involved, especially if you think that there's some family resentment brewing or something under the surface that you think may explode when you're not there to referee anymore.
Okay, so wills. What about a handwritten will, and what about some of those do-it-yourself online wills?
I'll defer to my legal friend there.
Sure. So handwritten wills are valid as long as they are exclusively in the handwriting of the person who made the will and signed at the end. It's a practical issue. People don't like to go into as much detail when they're writing their own will, as opposed to typing it out on the computer when you can put in a lot more details with a lot more ease. So not unheard of, but better than nothing. In terms of those will kits that you mentioned, I'm going to give a similar answer. It's better than nothing, but probably not something I would turn to because they tend to be rigid. They tend to not allow you to mold them to your particular circumstances. And the best crafted estate plans and drafted wills tailor exclusively to your own circumstances. And that's why in most situations it's better to have a lawyer help you and work one-on-one.
Yeah, significantly, it's a function of the complexity of your personal financial life that drives the potential needs of a will. And having someone who knows you and knows what you have happening in your life and who can then look to provide guidance to you based on that information. For example, do you have corporate assets? Maybe a second will is worthwhile having in place. Do you have complex financial issues that you need to deal with? The complexity or size of your family. Have you been remarried? Do you have a spouse and an ex-spouse? All of these things need to be factored in and can make things extremely difficult for those who don't get experience-based guidance to put it together.
I was going to say that one of the big issues that comes up now is about U.S. statuses in terms of U.S. citizenship, and that takes another whole wrench. We meet a lot of people who have mixed marriages, you know, husband's a U.S. citizen, wife's a Canadian citizen, and that requires some specialty as well. But taxes in the same, you know, so people don't realize, you know, I haven't been living in America for 50 years, but meanwhile, America looks at your worldwide assets and they're going to tax you on that. So there are certain exemptions, but that's why you really do need to sit with a professional to find out what the situation is now as opposed to finding out the hard way.
If you have no assets or almost no assets, very little, do you need a will?
You still do. You always do. I just want to take the will conversation one step further, is then the investment standpoint, your beneficiaries for your registered accounts, so RSPs, your TFSAs, your locked-in retirement accounts, they're all actually designated outside of the will. So the designation is at your financial institution, and make sure that's kept up to date. So even if you update your will, make sure that you have everything else, all your ducks in a row. I'm dealing with a few situations right now, which is very unfortunate, that people forgot about their registered accounts. And now the money will be going to someone that they didn't really intend for it to go to. So it's very important.
What about the idea of getting divorced and having a will and not going ahead and changing your will and not realizing that all of your assets are going to your ex-spouse? That might be a big surprise. So there are definitely certain life cycle events that happen that really are times to review your will. Most people have their will from years back when they were taking a trip to Acapulco and they were just concerned about their children, who's going to be the guardian. Meanwhile, the kids are all in their 40s now, right? So it really is something that has to be reviewed on a regular basis.
Libby, I might just add on your comment about, you know, maybe you don't have, you think you don't have enough assets, et cetera. Like, I think, in particular, young people often are thinking this way and thinking, a will, it seems like something my parents should be thinking about. But, you know, when you're on the verge of getting married, when you're having those first kids, like these are the moments that they're sort of those trigger moments that get you into this conversation. And to Matthew's point, I think that first will is important. And you do that first will, and it may change 5 years from now, 10 years from now, 20 years from now. But getting into the rhythm of getting that started, I think, is really important.
Okay, when we come back, what you need to know about the people handling your estate and how to ensure your beneficiaries aren't scammed out of what they're owed. That's next.
People have wills that they made, as I said, years ago. They know where it is. The question is, does your spouse know where it is? And if you're traveling with your spouse and there's a common disaster, does somebody else know where the will is?
Welcome back. We hear the horror stories all the time. Siblings fighting with each other, sometimes even stealing. In-laws scrapping over money, and families fighting with the people who were entrusted to handle their loved one's estate to begin with. There's some particular pitfalls for people who are in a second marriage. Here's what happened to Isabel Smith.
25 years ago, I got married to my second husband, and he had 3 grown children at this time. The children were going to get equal shares of his estate. We owned the condo, tenants in common, so I only owned half of the condo and their dad owned the other half.
That's 79-year-old Isabel Smith talking about the ordeal that she went through with her stepchildren and lawyers after her husband of 25 years passed away. And even though they had a legal will set in place, things did not go as planned.
When my husband passed away, I went back to the firm that we dealt with, and unfortunately both of these lawyers had retired, and they had assigned me someone else. And she told me, well, unfortunately, you're the beneficiary of his tax-free savings and his RIF and his investments. And I said, well, that was not what we had agreed to. In the meantime, I had heard from their middle daughter, and she said, what is the gross amount of your dad's estate? And I said, unfortunately, I can't tell you that because I am still the beneficiary of his RIF money and his tax-free. And she said, oh, no, you're not.
And to make matters worse were the rising lawyer fees and the introduction of a real estate lawyer.
And of course, I didn't realize till the first bill came in how expensive this was to have this. It was over $5,000 for the first bill. And with this conflict going on, I thought, oh dear, I want to just get out of this. And I made a proposal to his children that I was willing to buy them out of their half share.
Of the condominium.
Of the condominium, yes. And I said, but I do not want to go into debt. I am willing to give you the value that the condo was assessed at when your dad passed, and it will probably take me maybe 6 or 7 years to pay it off. And her lawyer got in touch with me and said that they wanted a mortgage on the condo.
Isabel knew she didn't want a new mortgage and eventually settled on a promissory note with annual payments to the children. She says she's learned a lot from this ordeal.
This is why I got in touch with the ZooMer magazine, because I'd like, a lot of widows are left to handle their husband's estate. And I think before it gets to that stage, you need to sit down and talk with the beneficiaries while the person is still alive so they can clear up any misunderstandings.
Experts say situations like this one are unfortunately quite common, especially when stepchildren are involved. And it's important to make sure that your will is ironclad. And as Isabel mentioned, it's best to talk things over with beneficiaries beforehand if possible. Here in Waterloo, Ontario, I'm Darren Maharaj for theZoomer.
So I guess a couple of things come up there. We already talked about the problem of not changing a beneficiary. And if people, once you set up your team, I guess you should have an idea in advance of what it's going to cost.
Well, yeah, so we have something very fortunate in Canada that if you have a spouse, all of your assets roll over tax-free to your spouse. It's called a tax-free spousal rollover. But on the second to die of a husband and wife, that's when the government has their hand out and they want, if you have anything over $220,000 in registered money, they want 54% of that. If you've had any stock or any investment properties, not including your principal residence or marketable securities, they're going to want 27% of the gains on that. And of course, if you have a holding company and you've got money there, they probably want somewhere around 47%. So I was just speaking with a lovely lady from Hamilton last week who had a nice estate of about $10 million. And I was saying to her, you don't have an estate of $10 million. You're only worth $6.5 million. She was very offended. What are you talking about? I have $10 million. I said, no, really, $3.5 million was going to the government. And that got her attention because now when you have that, now we can start talking about planning to reallocate money that's going to the government to maybe use things like tax-exempt insurance to save that for their family or for charity.
In fact, significantly, I think the biggest favor people can do in anticipation of the end of their life is to explain what they'd like to have happen. It's not unusual for a second marriage couple to do exactly, husband leaves money to his children, wife leaves money to her children. The children should understand that and be part of the discussion so that it isn't a surprise to them when you've passed away and now things are being cleaned up and everybody's going with that. It's not what I expected. It's critically important to bring them in the process.
Yeah, that's in general. Families should be told. And you also brought up a good point. You have to tell them where the will is.
It's unbelievable. You know, people have wills that they made, as I said, years ago, so they know where it is. The question is, does your spouse know where it is? And if you're traveling with your spouse and there's a common disaster, does somebody else know where the will is? You know, we've seen terrible situations where there's an emotional event that happens, and then right away there's a financial event. Where is everything? And of course, everyone has one of those drawers, you know? So you find like the forensics, and you have to, but that, you can make it so much easier. We've created a writable PDF estate directory at our website. You can download it, but it's basically, you know, who's the lawyer, who's the accountant, where's the will, where's the keys to the safe deposit box, what about digital passwords? What are the passwords
just going to say.
To the banks? We're living in a digital world. All your affinities, your credit cards, your travel, it's all has to be, it's got to leave your 2 ears, you know, area and put it onto paper and let somebody other than your spouse know where it is at all times.
Bob, I just want to pick up on your point as well. I think one of the challenges too is there's probably in this scenario you were describing, in those families, they're avoiding the difficult conversation, right? And they're really just sort of saying, you know what, like I don't want to go there with my kids and my in-laws' kids, etc. And it's just I'm trying to avoid it. And the problem is that when we avoid those things, the problems later on are so much worse, exponentially worse. And we were talking about cost earlier, right? Like, so sometimes a barrier to set up a will for some people is the cost. But I think to think about, you know, when you die without a will, the cost involved there is exponentially more. And so those are the things to mitigate those in the front end, is to really have some of those difficult conversations on the front end to mitigate the back end.
Okay, I want to talk about some of the dirt here. So what happens when there is some kind of malfeasance? This happened recently to somebody I know. She was the executor, one of 4 kids, and she found out that the one brother who lived in the same town as the mother has been stealing money. And they didn't want to, you know, they wanted to settle it very quietly, but he stole in 6 figures. He had power of attorney because he lived close by, stole in 6 figures.
Well, it's a sad story, and as I said, it's unfortunately not uncommon. And in a case like that, it's the executors, the estate trustees, who are tasked with going after the debts of the estate, or the credits of the estate, I should say, and may have a claim against anyone who they feel has stolen from an individual while they've been alive, or anyone who may owe the estate money. And that's when you really start seeing people in estates and beneficiaries get dragged through the dirt. that's when the real problems start, which is unfortunate.
Matthew, is it fair to say as well, like I think I remember hearing when we did our will, your executor and your power of attorney, you should really try to keep those two people separate. And they should really, they have distinct roles, and you shouldn't mix that for the most part.
Yeah, I see a lot of people who like to do that. A power of attorney becomes invalid right at death. So yes, a lot of people like to keep that separate, but on the other hand, a married couple with no kids, for example, will frequently want to just name each other as their attorneys or their estate trustees. So practically speaking, it may be a very difficult thing to separate. But at the same time, you do have to be aware that there are risks there. Every choice may have an impact, and that's one of the choices that may have a big impact. There are also cases, and unfortunately I see it all the time, where estate trustees, executors, have helped themselves to portions of the estate under the nose of the beneficiaries and hope that they're not caught or hope that it's just forgotten about. I had one estate that I was dealing with recently that wasn't administered for about 19 years. So the estate was an adult, basically. And they had just hoped that everyone would kind of forget about it and it would just slip under people's noses. And it did for a long time until the beneficiaries finally got wind of it. So it's important to keep on top of these things. Even if you're not a representative of the estate, even if you're not the estate trustee, if you're a beneficiary, you're entitled to information as well. And you have to make sure you stay on top of it, just in case.
In the charitable context, it's interesting because oftentimes charities will be named as the beneficiary in a will to a portion of the assets, and what oftentimes many charities will say, and their scenarios will come into play where the family who maybe some of those conversations didn't happen, to your point earlier, Bob, and the family will be surprised that charity X, Y, and Z are getting a portion of the estates, and they will sort of stand up and say, hold on a second, like I thought we were entitled to that's coming to us, and they'll fight it, and so there's the family stuff we've been talking about, but it often happens as well in the charitable context too.
Okay. When we come back, we will discuss preparing for a childless death. That's next.
Do you really want Cousin Vinny you've never met in the last 20 years to get a piece of your estate? Or do you want it to go to good work for something that you are familiar with, such as a charity or a foundation or a community organization?
Welcome back. Not everyone has an obvious heir. If you've lost a spouse or are childless, it will make the process of estate planning much more difficult. My husband and I are in that situation, and it certainly means we have to update our wills more often. And it's not just a matter of who will inherit our assets, who will be our executor, and what about powers of attorney? What happens to an estate when there is no next of kin or a beneficiary? Okay.
Well, I'm available for adoption in case anybody's in that situation, or certainly Anil here at the Toronto Foundation can help too. Look, we have certain rules in Canada that if you don't have a will and you die intestate, there are rules there which stipulate the first $200,000 goes to your spouse, and then the remainder gets divided up between your spouse and any minor children. So we'll put that aside if you have a spouse and you die intestate. Otherwise, it's going to be really a free-for-all. They're going to go to your next of kin, close. If it's not your children, right? So then they'll be looking at your parents and your siblings, and then of course if they don't exist, other cousins or people can be coming forward as well. So that's why it just comes to the point of really making sure you have the will, because you'll suddenly notice that you have new relatives you didn't even know about.
But you'll be dead, so you won't notice maybe.
That's true. That's true.
I'm just saying.
I think the significant issue, however, is the purpose of a will and the whole life planning process that gets you there is to have happen what you wish for. And if you don't pay attention to it, if you don't spell it out, what you expected or hoped might happen when you pass away isn't going to be the case. And it's particularly an issue if you don't have children. Do you really want Cousin Vinny you've never met in the last 20 years to get a piece of your estate? Or do you want it to go to good work for something that you are familiar with, such as a charity or a foundation or a community organization, or maybe in fact not a family member, but a friend who has made a big difference in your life as you got older? These are all important considerations to spell out, and if you don't put it down to paper, then you leave the world to risk as to who's going to get what.
And imagine, now you bring in the tax issue, right? So imagine somebody has an RSP or a RIF, and they don't have a spouse, and now they don't have children, or so that's going to be fully taxable. So $1 million RIF is going to only be worth $460,000 to some beneficiary. However, if you're charitable and you're looking at creating a legacy, or there are institutions or places that are very passionate, then you could come over here to my left over here to Neil at Toronto Foundation. Instead of having that $1 million go to the government, 54% of it, it could actually all go to charity, in which case the government doesn't get the 54%, and you can be remembered for leaving $1 million to charities of your choice. Think how great that would be in terms of creating a legacy for yourself and really making, you know, a very, very important message to the world that you created something very powerful.
So we talked a little earlier about powers, about assigning an executor. So, but if you're childless, what about the powers of attorney? Because those are really important. You can name your spouse, but there could come a point where they're unable to execute that. There's both a power of attorney for finances and for personal care.
Yes. I think there you need, at some point in your life, you need to know someone or have someone who, I mean, perhaps if you are childless, a child of a sibling or a friend who's younger enough that they can carry on those responsibilities. And critically, they have to share your values. For a healthcare power of attorney, they have to understand what you wish for in terms of the level of care that you do or do not want to receive when you're nearing death. Someone who you can completely trust and who has perhaps the same financial and circumstantial background you do, so they can appreciate what your wishes are through both the power of attorney while you're still alive and the will once you've passed away.
What do you do if you don't have such a person?
There are professional services out there that can help you through it. Usually, actually, when you don't have any children, you actually become even more diligent. You do your homework, you make sure that everything is set. So that's something that I see a lot with our clients. They make sure that they have either, if they don't have someone to support them, they hire a company to support them, whether it's a bank, independent trust companies, and then they end up being actually quite charitable. And then they can have someone like a Toronto Foundation help and continue their legacy after they've passed.
In terms of, so families without a next of kin, I think the idea of giving to charity is absolutely something that many of those families would welcome and consider, because the concept of leaving one's legacy and thinking about what your values are and how those align with how you want to be remembered. You know, we're an example. So the Toronto Foundation works with individuals and families to set up charitable legacies. There's thousands of charities across this country that are doing incredible work in all aspects of spaces, from healthcare to animal welfare to the environment, community development. And I think what's important is that for all of us, once we have a real good sense of the area that we care about and want to focus on, is finding those partners that can help us do that. And I think that's where a community foundation can come into play. There's 200 community foundations across the country. And then there's, as I said, so many incredible organizations right on the ground doing the work, doing the heavy lifting that can really help families in many stretches.
Okay. When we come back, we'll take some questions from the audience. That's next.
How do you fund the money that's going to be there in order to take care of your son and be able to provide an income for them? Because why give it to government when your child could use it, you know, to take care of them in their lifetime?
Welcome back. Now it's time to take questions from our audience, starting with Alan.
Hi, my question revolves around the phrase joint ownership with right of survivorship, and how that applies to someone's house or bank account. And if that is the case, how does that apply to the probate taxes. Like, is it a percentage of the probate tax if it's 50-50, for an example? And another thing is that account also frozen and it has to be released at a certain time? So
joint ownership with the right of survivorship, that means that if two people are owners of a home or holders of a joint bank account, that means when one passes away, ownership of that is automatically vested 100% in the other owner, which means that that asset does not pass through the estate. It is not subject to probate taxes, and it's a very common way for people who jointly own assets, say a husband and wife, spouses, or any other connection, save a bit on probate taxes. So that would not be subject to tax.
So bank accounts would not also be frozen?
Once it's once one of the holders passes away, it is deemed to be owned completely by the other individual, which means it should continue to be operational and you should be able to continue transacting within that account. It should not be frozen.
Thank you.
Thank you.
Hi there, what's your name? What's your question?
My name is William Mosher, and my question is, how do you start planning your estate when a family member has special needs? Like in my case, I have one son, but he has autism. So where do I go and how do I start planning?
While you're alive, there are things like registered disability savings plans, which is a form of trust which can be established for the benefit of a child with needs. Additionally, through your will, you can set up a trust in your estate that will put funds aside for the support and maintenance of a child's needs, both medically and from other living costs perspective. And the key thing there is you're leaving the estate trustee or the trustee of the trust that's established with a very long-term obligation. So whoever's going to be managing the funds for them needs to be known, trustworthy, and capable of handling the job for as long as need be.
And that might actually bring into play things like life insurance. Like, how do you fund the money that's going to be there in order to take care of your son? You know, if things are tied up in real estate, so you have hard assets or you don't have cash, life insurance could be something that was provided. So, and again, it would go into a trust of some kind and be able to provide an income for them, because why give it to the government when your child could use it, you know, to take care of them in their lifetime?
Thank you. When we come back, final thoughts from our panelists. That's next.
Previously this season on theZoomer, we spoke about Canadian healthcare. On Twitter, Laurel tweets, "I always think of how grateful and lucky I am to have been born in Canada. I've had my 4th surgery in 2 years, countless x-rays, bone scans, 2 MRIs, and CT scans. And the only medical bill I've received, $90 for 1 cast. Hashtag Canadian Healthcare." On another previous episode of theZoomer, we discussed home sharing. On Facebook, Lily writes, "More people are trying to move into homes in the Greater Toronto Area, but there are limited opportunities to do so. Especially with housing prices rising, it makes sense for communities to consider home sharing programs. We need to do more to address the housing crisis in our city." Keep the comments coming in and connect with us on Facebook, Twitter, and via email at rsvp@zoomermedia.ca. Don't forget, for free tickets to the show, go to www.universe.com and search Zoomer Media, and log on to www.thezoomertv.com for full episodes and more.
Welcome back. It's now time for final thoughts from our panelists, starting to my left.
So to wrap up, it's I think it comes back to what I said initially: planning versus investing. Planning is making sure you have enough money for retirement, what your taxes are now, what they're going to be in the future, how much never spend money are you just going to be holding on to for the next generation, and figuring out, can we use that money to preserve your estate using things like life insurance so that your family gets everything as opposed to a smaller percentage.
All right. I touched earlier on the idea of really thinking about the charities that align with the values that you have. And I think to just go one step further on that, so at torontofoundation.ca, our website, we have a product, something called the Good to Give Guide. And in here, it's basically a catalog of giving opportunities that are vetted and thoughtful and things that people might consider. So if people are having questions and wondering, what am I interested in? How might I do that? A place like that can really give you some of those tools that help you when you're thinking about a bequest fund or any of these other ideas in your legacy.
I tell a lot of people that it's a good idea to share your wishes with your beneficiaries, and sometimes the answer I get is, well, I don't want to, it's none of their business. And that's not completely wrong, but at the same time, I would answer that with two things. Number one, they're probably going to find out about it at some point when you pass away. And secondly, if you're doing something that's a little bit non-traditional, say splitting money unequally or inequally between your children, this gives you an opportunity to explain, to play referee, to justify why you decided to do what you did, and may avoid some costly estate litigation down the road.
Estates and wills are really the end of a life planning journey, and I think the critical thing people need to think about is that the lifelong financial planning process, if handled properly, allows you to think way ahead on things like, what happens to the family cottage when I pass away? What's going to happen with my business? What happens in the example that my kids have different needs or I intend to split assets unequally? All of those things are best handled by a long-term plan rather than a last-minute surprise.
And I would say start right away. Start as soon as you can. Even if you have these thoughts in your head, start actually putting it down on paper, talking to a professional, and having it actually take place.
Okay. Not only is dealing with the prospect of our own demise uncomfortable, estate planning involves a lot of decisions that are not necessarily easy. It's a process. I procrastinate too, but I firmly believe that getting it done will surely bring peace of mind. Thanks for being with us. We'll see you soon. It's time to zoom out.